Good afternoon, everyone, and welcome to today's program, The Anatomy of a Bad Trust Administration, How Routine Decisions Turn into Litigation. My name is Teal Schoonover. I'm a co-chair of the Beverly Hills Bar Association's Trust and Estates Law section. Before we begin, I'd like to take a moment to introduce Nancy Sanborn and Brian Joy of the Sanborn team. Nancy and Brian have been the official sponsor of this section since 2006.
Wow.
Nancy and Brian, go ahead.
Thank you so much, Teal. As you may know, there are a lot of agents out there that are not familiar with selling property that's held in trust. A lot of them don't realize that the trustee is an exempt seller and often have them complete disclosures that they're not required to do so.
A property that is being sold by a successor trustee should be handled very similar to a probate sale. The only difference is that it does not have to go to court to be confirmed unless there is an objection to a NOPA. It really isn't, sorry. It really is important to vet an agent and make certain that they are aware of the anatomy of a trust real estate sale. Have a great meeting, you guys.
Thanks, Nancy and Brian. In addition to the Sanborn team, the Trust and Estate section is also sponsored by Bond Services of California, Liberty Mutual Surety, California Title Company, and Pickford Escrow Company. Now I'd like to turn things over to Laura Zolnikoff to provide this month's legal updates. Thanks.
Good afternoon, everybody. Today I'll be covering one new case and one new statute impacting trust practice. First, Elijah and Mary Steiny Trust v. Robbins. This case highlights how courts outside of California apply California trust law when the trust says they must. In this case, the parties reached a settlement in Arkansas, but the court refused to approve it because under California law, the agreement modified the trust and required notice to all interested parties. The key takeaway here is that governing law clauses matter. Even in out-of-state litigation, California notice and fiduciary rules will control. Second, California Assembly Bill 565, which was effective January 1st, 2026. AB 565 expands virtual representation, allowing certain individuals, like trustees or beneficiaries, to bind others, including minor children and unborn beneficiaries, without direct notice. This will streamline trust administration, but it shifts litigation. The key disputes will now be whether interests were truly substantially identical and whether conflicts of interest existed. In short, expect more efficiency in administration, but more litigation, overrepresentation, and conflicts. Thank you for your time, and I will now turn the meeting over to Rochelle Schultz.
Hi, I'm delighted to introduce our speaker, Lindsay Munier. Lindsay is a partner at Keystone Law Group, a certified specialist in estate planning, trust, and probate law, and holds an LLM in taxation. She represents fiduciaries and clients in complex trust and estate disputes, handling all phases of litigation as well as estate and trust administration, often involving high-value estates. Lindsay also brings a strong background in tax planning and controversy, and is a recognized thought leader who regularly teaches, publishes, and speaks on probate and estate matters. And now let's get started.
Thank you, Rochelle, and good afternoon, everybody. Thank you for being here. We're just going to have the PowerPoint brought up right now. There we go. Okay, so as Rochelle said and everybody said, today we're going to be talking about what can essentially go wrong with a trust administration. And I'm going to be looking at this obviously from the perspective of a litigator, as that is what we primarily deal with. Go to the next slide, please. I want to start off with a few sort of general comments. In my experience, most litigation in this area doesn't start with outright fraud by a trustee or by the trustee intentionally acting improperly or intentionally mismanaging the trust assets. It really comes about because of small missteps that compound over time, and which the trustee may not even be aware of as an actual misstep. So one thing that we're going to be talking about a little bit today, and one thing that I think is important for fiduciaries and for practitioners to be aware of, is that intention doesn't really play a huge role in this area in terms of breaches of fiduciary duties. The other thing that really gives rise to litigation in this area is the gap between what a fiduciary thinks that their role is versus what their role actually is. A lot of times when I'm talking to trustees who have recently been sued, it's very apparent that they didn't know that what they were doing was improper, or that there was any liability that gives rise to the actions that they were doing. And so it's important to not only have counsel advising you about what you should and shouldn't be doing, but to understand that when you need counsel is important. In this presentation, we're going to start off talking about what the duties are of a fiduciary, what all of the obligations are, and then how those obligations can go wrong. And then we're going to end with a case study to go through this and show an example of how this can play out in real life. Next slide. Okay, so phase one, immediately post-death. In this presentation, we're really going to be talking about a fiduciary who is acting as a trustee following the death of the settlors. So we're not talking about the settlor trustee, for instance. This is somebody who is stepping into this role after the death of either the only settlor or both settlors of the trust. And oftentimes this is a child of the settlors. So immediately after the death, the trustee does have an obligation to marshal and safeguard the assets of the trust estate. Marshaling the assets meaning to take control of those assets, to really understand what is a part of the trust estate so that you can start to administer those assets. And then again, once you understand what kind of assets you're dealing with, then the next steps come into play, one of which is to obtain date of death valuations for those assets. And the date of death valuation is very important for a number of reasons. Number one, you need to know what the total value of the estate is to determine whether or not an estate tax return is going to be necessary to be filed, or if an estate tax is actually due. And you won't know that until you know what the date of death valuation of all of the assets are. Secondly, you will need to know date of death values in the instance of selling any of these assets in order to determine whether there is a capital gain or loss on that sale. And depending on the assets that we're dealing with, the further in time that you get from the actual valuation date, which is date of death, the harder it may be to actually value those assets. So certain assets may not be difficult to value, years down the line when you're getting ready to sell it if you forgot, but some assets may be difficult. And those include business assets, family businesses, things like that are already inherently difficult to value. And then the further in time we get from the actual valuation date, that can become more problematic. So this is something that the fiduciary should be aware of at the beginning and to take steps to actually get accomplished. Overlooking illiquid or hard to value assets. This is really easy to do because most of the time people are thinking about the real property or the cash, and they may overlook other types of assets like business assets, especially if it's a family business. And if the successor trustee has already been involved in the family business, it can be easy to sort of just think of that as ongoing business and not that anything needs to change. What are some early red flags? Obviously, missing documentation from the trustee is going to be difficult in the event that litigation arises down the line. Having documentation to support the decisions that you're making is going to be incredibly important to either overcome that liability or to rationalize the decisions made. Additionally, confusion over roles. In situations where you have two co-trustees acting, there may be some confusion over what roles each of those individuals are playing, whether decisions have to be by unanimous decision or majority, whether one person can act alone. So really clarifying those roles up front is really important. And then additionally, agents of the fiduciary. So a fiduciary has a right to hire agents to assist them in administering the trust. And those agents can include an attorney, a CPA. It can, again, depending on the assets that are part of the trust estate, it can include property managers, financial advisors. And it's often prudent to hire those agents depending on the background of the trustee, whether the trustee has particular knowledge in dealing with those types of assets or not. And so hiring the agents is often a prudent course of action for a fiduciary to undertake, but remembering that it is still the trustee's obligation to administer this trust estate and to oversee the actions of the agents. So you can't just hire the agents and then step back and sort of be hands off. And then if there were prior fiduciaries, again, not talking about the settlor trustee, but if you're stepping in as a successor trustee after another trustee who is acting post-death, then you do have an obligation to look into the actions of that prior fiduciary to determine if there were any breaches, and then if it makes sense to take action to redress those breaches. And then on this last point, we're going to get to that in just a second. So we'll go on to the next slide. Okay, phase two, once you've determined what the assets are that you're administering and you started to take inventory of those assets and sort of get them under control, the next step is to start communication with the beneficiaries. And failure to communicate with the beneficiaries is one of the fastest ways to create suspicion among the beneficiaries about the actions that you're taking and will likely lead to litigation. So this is incredibly important. The very first thing that you have an obligation to do as the trustee is to send out what's called the notification by trustee. This is pursuant to Probate Code Section 16061.7. This is, for the purposes of our presentation, this notification is required upon the death, upon the change of a trustee, or upon a trust becoming irrevocable. And so in the situations that we've been talking about, once the settlor of the trust dies, that does occasion a new trustee, as well as usually the irrevocability of the trust. And so pursuant to the statute, you are required to send out this notification. And that notification does have to be sent to all beneficiaries of the trust, as well as heirs of the decedent. The effect of the notification is that it starts the statute of limitations for a beneficiary or an heir to contest the terms of the trust. And even if you don't anticipate there being a contest of the trust, so even in a situation where all of the individuals who you would expect to inherit are actually inheriting, you still want to send this out, not only because you have a statutory obligation to do so, but also because you never know what's going to happen during the course of the administration. And so it's good to have that statute running. It is a short statute, 120 days from the date you send out the notification, so long as you include a copy of the trust with it. And it's good to just get that going so that by the time that statute runs, you don't have to worry about potential litigation regarding the terms of the trust. Also, pursuant to Probate Code Section 16061.9, if you fail to send out this notification to an individual upon whom it's required, then the trustee can be responsible for all damages, including attorney's fees and costs, unless you're able to show that you made a reasonably diligent effort to find and serve that individual beneficiary with the notice. So in a situation where the trustee, for whatever reason, is refusing to send out this notification or provide a copy of the terms of the trust to a beneficiary, and they end up hiring counsel, and counsel has to file a proceeding to compel the trustee to provide a copy of this, pursuant to Probate Code Section 16061.9, it's very likely that that beneficiary will be able to collect attorney's fees from the trustee for having to hire an attorney for this. So again, very important document to send out at the very beginning of the administration. Additionally, throughout the course of administration, beneficiaries are entitled to information about the actions that you're taking. In my experience as a litigator, when I have a beneficiary call me who's upset about the way that a trustee is administering the trust, what they always talk about, and the sort of buzzword that I always hear, is accounting, right? They didn't give me an accounting. I asked for an accounting. They haven't provided an accounting. It's the very first thing that I feel like if you Google what are my rights as a beneficiary of a trust, it comes up, accounting. So the laser focus on a trustee's duty to account and a beneficiary's right to an accounting. And yes, that is correct. A beneficiary has a right to an accounting, trustee has a duty to account. But in my opinion, the more important duty and the more important information is under Probate Code Section 16061, which is a much broader right to information for a beneficiary. Under that code section, it says on reasonable request by a beneficiary, the trustee has to report to the beneficiary by providing them requested information relating to the administration of the trust relevant to that beneficiary's interest. So if the beneficiary is a residuary beneficiary entitled to a portion of the residue, anything that you do as the trustee of the trust is relevant to their interest because it's going to have an impact on the residuary share. Contrast that with a specific beneficiary, their rights to information under this code section might be much more limited, particularly if they've already been given their beneficial interest. But this code section is much broader than just an accounting. And so this is incredibly important for a trustee to understand, as well as for a beneficiary to be aware of. There is case law in California that talks specifically about this code section and says that the information to which a beneficiary is entitled under this section also includes an accounting. So this is very powerful code section giving beneficiaries very broad rights to information that extend beyond an accounting. Speaking of an accounting, Probate Code Section 16062 is the code section that gives the trustee the obligation to account at least annually at the termination of a trust or upon the change of trustee to each beneficiary to whom income or principal is required or authorized to be distributed. Section 16063 sets forth the format of the accounting. It is my opinion, if a trustee is providing an accounting to a beneficiary, but it's not necessarily in the specific format set forth in 16063, that's not necessarily a breach of your obligations because you're providing the information to the beneficiary. But if you are looking for court approval of that accounting, it will need to be in that format under the probate code. It's also important to remember, going back to this distinction between information and accounting, that the duty to formally account to a beneficiary can be waived either by the beneficiary themselves or by the trust instrument. But the right to an accounting and to a copy of the terms of the trust cannot be waived. So again, that 16061 right to information, very, very important for both sides to be aware of. Next slide, please. Okay, so now that we've covered what the obligations are for a trustee to communicate with the beneficiaries, what happens if that communication is not being done properly? So a lot of times we see trustees completely failing to give any information to beneficiaries, sort of blowing them off and just saying, yeah, I'll get to it, not really giving them any information or giving them inconsistent or incomplete information. Also, tone problems in the communication with the beneficiaries, dismissing the beneficiary's claims or concerns, their questions, getting really defensive as the trustee, and then potential perceived favoritism among different beneficiaries can also create problems. And the reason why this is important, because if you're failing to communicate with the beneficiaries or you're communicating with them improperly in a way that makes them think that something is going on, it's going to increase the likelihood of litigation, right? Because somebody who doesn't know something and who they feel is information is being kept from them allows them to think the worst, that something probably is happening. And so I might need to hire an attorney and pursue litigation. Next slide. Okay, phase 3, what are the actual fiduciary duties that a trustee has and how can they be breached? There are many duties that a trustee has. This is not all of them, but sort of the biggest ones that we see a lot of, the duty of loyalty. Obviously, this is the duty to administer the trust solely in the interest of the beneficiaries. This is breached by engaging in self-dealing and a transaction or an action that puts the trustee's interest over the interest of the beneficiaries, or engaging in transactions where there's a conflict of interest generally. The duty of prudence. This is a duty to properly manage and invest the assets of the estate. This can be breached by making poor investment decisions, concentrating risk in one particular area and not diversifying the risk among different asset classes or different types of assets. Delegation issues, as we sort of touched on a little bit earlier, over reliance on advisors. So again, hiring advisors to help out with the administration is often very prudent for trustees to do. However, if you do hire those individuals, you do need to continue to oversee their actions. It is not proper for a trustee to hire a bunch of advisors and delegate out all of the duties of the trustee to those individuals. And then if something were to go wrong, throw up their hands and say, oh, it wasn't me, it was the CPA that messed this up. I'm not responsible. At the end of the day, the buck stops with the trustee. It is the trustee's responsibility to administer the trust and to oversee advisors that are hired by the trustee. So yes, prudent to bring on advisors, but make sure that you're aware of the actions that they're taking, that they're running things by you, and that you have an active, ongoing relationship with them. One of the biggest duties here is the duty to make trust property productive. Depending upon the type of asset that we're talking about, this for real property, for instance, this could mean renting it out during the term of the administration, or selling it. On the other hand, this could be breached by allowing renters to stay in the property rent-free or for much below fair market value rent, or the trustee themselves moving into the property and living rent-free, which we see a lot of. And then the duty to preserve trust property. Obviously, paying the mortgage on any real property on time, paying property taxes, not allowing the property to fall into foreclosure, or to face public auction for failure to pay those taxes. Next slide. Okay, back to the accounting. Again, the accounting is a very important part of the trustee's job. It's a very important part of keeping the beneficiaries aware of what you're doing. So when you are getting ready to account, you need to make sure that you're starting this process at the beginning, because usually you don't have to account for at least a year. I mean, there's no like strict rule on this, but that is generally what is thought about. I have beneficiaries contacting us, a couple of weeks after the decedent died, saying they haven't accounted. Well, it's been a few weeks. There's probably not much to account for at this point. However, even though you may not be able to formally account a few weeks after the decedent's date of death, you should be taking actions to make sure that when you are going to provide that accounting, you have the information ready to do that. So you need to maintain records from the start of your administration. You need to make sure that you have all receipts of any disbursements that are made. You have evidence of income that has come in and where it was deposited. You need to make sure that you're not commingling your personal assets as the trustee with assets of the trust. If you are making informal accountings to the beneficiary for whatever reason, you don't want the expense of a formal accounting, you're not seeking court approval, make sure that if it's an informal accounting, it's still complete and it has all of the information that you would get in a formal accounting. Obviously, resisting providing an accounting or financial information, again, like we've said, is going to cause problems. It's also a breach of your fiduciary duties. And these accounting disputes often become the battleground for litigation. Next slide. Distribution. So when it is time to make distributions from the trust, some trusts, not all, but some trusts do provide for discretionary distribution to beneficiaries. And a lot of times those discretionary distributions are based on a HEMS standard, health, education, maintenance, and support. And so this gives the trustee discretion, which ultimately can lead to claims of breach because of that discretion. So really having to understand what the standard of your discretion is and that you're applying it consistently across beneficiaries. So here, inconsistent distributions among beneficiaries per se, in and of itself, may not necessarily be a breach because there may be different beneficiaries entitled to different things under the terms of the trust. So it is not proper to say across the board every beneficiary should be treated the same. However, the important rule here is that like beneficiaries should be treated like. So if you have equal residuary beneficiaries entitled to discretionary distributions according to HEMS, and you're making distributions to one beneficiary for educational purposes, but just refusing to do it for another one, even though they're asking for similar educational expenses, that could be considered a breach. So if you are going to exercise that discretion disproportionately among beneficiaries that are the same under the terms of the trust, you want to make sure that you're documenting why you're doing that. And if you have supporting information for those decisions, make sure that that's involved as well. The other part that comes along with distributions, in this area of the law, we're always dealing with emotions, right? Because we're oftentimes dealing with family members. And so there could be an emotional overlay to these decisions, both by the trustee and also the way it's viewed by the beneficiaries. Lifestyle expectations, there are certain circumstances where perhaps during the life of the parents, the settlors of the trust, they were making monthly gifts to all of the children or some of the children. And so there may be an expectation that will continue post-death, but the trustee does not necessarily have an obligation to continue to do that. So you really have to follow the terms of the trust, but make sure that you are exercising that discretion the same or equally among the beneficiaries. Next slide. Tax and administrative errors. Obviously, taxes are incredibly important when it comes to administration of a trust, and messing up with taxes is going to very often result in damages to the trust. And so here, we've talked about some other potential breaches. Maybe those breaches didn't result in any damage to the trust, but if you breach your obligations with respect to taxes, it's likely going to lead to a financial penalty or interest charge against the trust, which is a damage, and that can be a basis for a surcharge against the trustee. So this is incredibly important. And unless the trustee is a CPA themselves or has experience in fiduciary income tax returns, hiring a CPA with experience in this area is going to be incredibly important. Filing returns timely and paying taxes timely is of the utmost importance. As a fiduciary, you have an obligation to file fiduciary income tax returns for every year that the trust is in existence. In addition to that, to the extent that the trust estate is large enough to warrant an estate tax return or that's an estate tax, you will also have to file that return. And then one thing that is often overlooked by fiduciaries is filing the decedent's final tax return. So this is the decedent's return from January 1 of the year that they died until their date of death. And so as the decedent's successor in interest, it is incumbent upon the trustee or the executor to file this final return and pay any taxes associated with that. So something that is often overlooked, but is also very important. Again, failing to file these returns timely or to pay any taxes associated with them can expose the trust or the estate to penalties and interest, which is going to be a liability of the trustee. The other important tax consideration is property tax considerations. A lot of times people are focused on income tax issues, and property tax issues can be overlooked. Making sure, obviously on date of death, there's going to be a reassessment for property tax considerations unless there is an applicable exclusion. Most people are aware of or know about the parent-child exclusion, and before 2021, it was very easy to get that exclusion. Post 2021 with Prop 19, this exclusion has been significantly reduced. So understanding whether you're entitled to it, and if you are entitled to it, making sure that you are timely electing for that exclusion so that you can avoid a reassessment or at least reduce the reassessment and reduce your property tax liability. The Prop 19 changed the parent-child exclusion. Now, in order to get the exclusion, the child has to be living in the property as their primary residence, as reflected on their income tax return. And it has to be 100%. So the child living in the property has to have 100% interest in that property in order to get 100% exclusion from reassessment. So if there's a piece of real property that gives, if there's a trust, that gives this real property to 3 different children, only one of them is living there full time, you will get an exclusion from reassessment up to 1/3 of the value of that property, but 2/3 will be reassessed. So understanding that this can be the difference between being able to keep the property or not keep the property. So being aware of this early on and planning for it and talking to the beneficiaries about it is something that the trustees should do. Okay, so this is sort of a broad overview of the duties of the trustee and when things can go wrong. And then what happens when they do go wrong? When we get to the escalation of the beneficiary saying, look, I'm seeking legal advice and we're going to file a lawsuit, the common claims that arise in this arena are breach of fiduciary duty, failure to account, and then seeking removal or surcharge of the trustee. Next slide. Okay, practical takeaways. Obviously, you really want to front load communication and transparency to beneficiaries. Keeping them informed of everything at the beginning and as you go along through the administration is really going to be able to cut back on any claims that they may make after the fact about not knowing something. If you can show that you did tell them and they either didn't respond or consented to it, that can reduce the potential for litigation. Documenting everything so that not only do you have the documents to provide to the court in the event that litigation arises, but it can also help you remember if we're talking about a multi-year administration as to why you did something. So if you don't have something documented, you may not remember exactly why you made the decision that you made. Use professional advisors, but supervise them. This extends across the board from attorneys, CPAs, property managers, everybody. Make sure you're taking advantage of people who have specialized knowledge that you may not have, but make sure that you're staying involved. Make sure that you're implementing an accounting system early on and that you have the information necessary in order to provide complete accounting. And then know when to seek legal advice or legal guidance. And in my opinion, that is at the very, very, very beginning. Next slide. Okay, so let's go through sort of a case study of how this can play out in real life. This is a hypothetical case study, not a real trust, not a real fact pattern. Next slide. Okay, so we have the decedent, Robert Smith. He's a widower, dies in 2024. He set up a revocable living trust, which becomes irrevocable upon his death. The key terms, upon his death, there's an equal distribution to his 3 children, Emily, Jason, and Lily. Jason, who is the middle child, is the named successor trustee, and the trust calls for discretionary distributions for health, education, maintenance, and support prior to the final distribution to the beneficiaries. The assets of this trust are a primary residence, which is worth about $2.5 million, an investment portfolio about $3 million, and then a closely held family business, which has been operated by Jason. On paper, this looks like a very common, seemingly low-risk trust administration. Next slide. Okay, so immediately post-death, what sort of missteps does Jason take? Jason delays getting a date of death valuation and notifying financial institutions. Again, the date of death valuation is important in this case because there is that closely held business. Closely held businesses are very difficult to value. And so the further in time you get away from the valuation date of death, the more difficult it may be to value that asset. So getting that date of death valuation is incredibly important. Also, in this case, the fact pattern doesn't tell us doesn't give us any idea of what the value of that business is. Based on the other assets, we're talking about a $5.5 million trust estate, which is significantly below the estate tax exemption amount. However, depending upon the value of this business, that might set us over the exemption amount. So being able to get that valuation as early as possible so that you can determine whether or not an estate tax return is necessary is important, because that estate tax return does need to be filed within 9 months of date of death. So it comes up very quickly. And like I said, these valuations are difficult and time consuming to do. So you want to start that process immediately. Also notifying financial institutions in certain circumstances with real property. If there's a mortgage on the property, sometimes there'll be a provision that escalates the payment of that mortgage upon the death of the borrower. So it's something else that you want to be aware of, especially when if you are going to notify a financial institution about the death, knowing that that might happen is something that's important. Jason also continues operating the family business informally as his father did without any clear accounting, and then he moves into the home temporarily. So let's talk about operating this family business. One of the things that I hear a lot of from trustees who come to us once they've been sued is, I just did everything the way that my dad did it or the way that my parents did it while they were alive. And they're saying this as if that is a get out of jail free card, where it's like, you know, I just did what they did, and so it's okay. That's what they wanted, and that's what I just did. And the response is that unfortunately that's not how this works. The actions that a settlor principal can take with respect to their own property is very, very different from a fiduciary's obligations with respect to those same assets. So during my life, I have the right to do whatever I want with my own money, right? I can invest it in very risky investments. I don't have to diversify any of that. I can spend it all on whatever I want, make imprudent investment decisions, spend like a spendthrift. I can do whatever I want, and I don't have to answer to anybody, assuming I'm not married. But as a fiduciary does not have that right. A fiduciary has to act in the best interest of the beneficiaries only. And so a fiduciary cannot, invest solely in high risk stocks. They cannot continue to operate things as the survivor did and use that alone as the reason why they're doing these things. If the settlor themselves was operating things prudently, then, and you're continuing to do that, then obviously fine, that's great. But in most circumstances, that's not what's happening. The settlor was charging way below fair market value rent to tenants because they'd been there forever and they knew them and they liked them. And then the trustee comes in and they just continue to charge that same rent, although fair market value rent is, maybe 2, 3, 4 times higher than that. So these are things that a trustee needs to be aware of, and thinking that just doing what your father did is enough, it's not enough, and they need to be aware of that. Finally, moving into the decedent's home temporarily, I'm going to assume this means that he's moving in there and not paying any rent. And of course, that is causing a damage to the other beneficiaries. This is self-dealing. Jason is getting a benefit from that trust asset that the other beneficiaries are not getting. So the problem here is that there's no separation between Jason as an individual and Jason as a trustee. There's a lot of commingling here and potential self-dealing. Next slide. Okay, then we move on to the communication breakdown. So Emily and Lily, the other 2 beneficiaries, receive very minimal information from Jason. They don't receive the notification by trustee. They don't receive the copy of the trust for several months. When they ask questions to Jason, he reassures them, saying, don't worry, everything's equal. Which, again, we hear a lot of. But months pass with no updates. So the impact of this is that the suspicion begins, and again, not necessarily because Emily and Lily are aware that there's any wrongdoing by Jason, although we know that there's some impropriety going on. They don't really know that yet, but because they're not getting any information and he's kind of blowing them off, they start to wonder, is something happening? Is he doing something that he's not supposed to be doing? Next slide. Okay, phase 3, here we start to see the breaches sort of escalate. So Jason starts paying himself a management fee from the assets, but he doesn't document it. Again, he keeps running the business, but he's not distributing any profits. He's concentrating all of the investments instead of diversifying them, and he's not keeping any records for any of the decisions that he's making. So now we have, again, self-dealing concerns. We have the breach of the duty of loyalty and prudence, and we don't have documentation to support these decisions. Paying himself a management fee may not be a problem. Trustees are entitled to compensation for acting as the trustee, but what is the amount that he's taking and how is it calculated? If he's not documenting that and he's just pulling a number out of the air, that's not going to fly. It has to be tied to something. Next slide. And then we move into the accounting issues. So Jason does not prepare any formal accountings. The trust and the business finances are commingled. When the beneficiaries do request information from him, he only provides them with informal spreadsheets, and key transactions are missing or unclear. So again, going back to this informal versus formal accounting. Again, it's my opinion that if the trustee is providing the beneficiaries informal accounting, and that can take the form of just providing them with the bank statements, or the bank statements in conjunction with like a spreadsheet in this case about what are the expenses, what's the income, and it's not in the exact format that is set forth in the probate code. I don't think that that's a breach. You're providing the information to the beneficiaries. It's just not in a particular format. However, the problem in this case is that there's key transactions that are missing or unclear. And that's when you're going to have a problem, because this is not a full and complete accounting. I don't know why these transactions are missing or unclear. It could be because it's improper and he doesn't have rationale or a justification for those transactions. It could be because he's missing the receipt or the substantiating documents for those transactions. Whatever the reason, this information that is being provided is improper, not necessarily because it's informal, but because it's missing key information and it's not giving the beneficiaries a clear picture of his administration of the trust. And so here we have, and this is really where you get the beneficiaries, where they start to hire counsel, because now they have a document that shows some kind of impropriety or something's missing here. This doesn't add up. And so now I think it's time to hire counsel. And that's exactly what happens in this case. Emily decides to hire counsel. Next slide. Okay. We also have distribution disputes. Here, Jason makes a very large distribution to himself, claims that it's a reimbursement. I'm assuming that he doesn't have the documentation to support that reimbursement, and then makes smaller inconsistent distributions to Emily and Lily, and he justifies these decisions vaguely under the HEM standard. Now, remember, we talked about this. In this case, these three individuals are entitled to the same distributions from the trust. And here we can see that they're being treated differently. Now, it may be okay that reimbursement to Jason may in fact be a legitimate reimbursement. And so it might be okay that he paid himself much more than he paid Emily and Lily. But based on this, it's not clear that Emily and Lily are able to determine that, because there's a lack of documentation to support the reimbursement, and there is no justification for the distribution to Emily and Lily. Why is he distributing them less? What is the basis for the amount that he is distributing? So even if it's permissible on its face, it looks like favoritism. In addition to that, a trustee has the burden of proof with respect to their actions in the administration of the trust. So if you are submitting an accounting, any disbursements that are made, any distributions that are made, if you cannot justify that disbursement or that distribution, it's going to be, the court is going to find against the trustee, because it is the trustee's burden. It is not the beneficiary's burden. The beneficiary do not have equal access to information that the trustee does. So it's the trustee's duty to keep records of what they do, to be able to justify the actions that they take, and to be able to support those actions with documentation. And if the court doesn't have enough information to be able to say, yeah, that seems like a legitimate distribution, then it's going to be determined to be improper. And then on tax side, Jason he files the fiduciary income tax returns late. He doesn't make the appropriate tax elections, and penalties are incurred. Okay, again, now this case has damages that are assessed against the trust estate. which is a problem for Jason. And that will escalate to a legal claim. So Emily and Lily, who is also now represented, send a demand letter to Jason alleging that he's breached his fiduciary duties, he's failed to account, and he's engaged in self-dealing, and they're requesting a full accounting, suspension and removal, and surcharge for damages. Jason's response to this, as it usually is that he is shocked. He believes that he was doing everything he was supposed to be doing. He wasn't intentionally doing anything wrong. He didn't mean to treat his, to keep his sisters from getting what they're supposed to be getting. But unfortunately, based on what we've seen, it doesn't really appear that way. Next slide. So they send the demand letter, and then they file in probate court. The key battlegrounds here are: what is the adequacy of the information or the accounting that Jason gave to them? What's the legitimacy of the compensation that he received? And then what's going on with the business? How does the business even play a role in this? Discovery reveals that Jason treated the business as basically his, and that there was a lack of documentation for all of the decisions, the major decisions that he was making. And so the reality when we're in litigation in a situation like this is that the paper trail, or the lack of it, so the lack of ability by the trustee to substantiate their decisions, is going to become more important to the court than what the intention was of the trustee. So regardless of the intention, whether Jason intended to treat his sisters improperly or whether he intended to breach, doesn't really matter, because at the end of the day, the trustee is the one that has the obligations with respect to the administration. And if they don't have the proper information to back up their actions, it's going to be held against them. Next slide. Ultimately, the case is resolved before it goes to trial, as most cases are. As part of that resolution, Jason agrees to step down as the trustee in favor of an independent fiduciary, and he agrees to pay a partial surcharge. Now, this is significant because, specifically for Emily and Lily, the beneficiaries, because Jason, I don't know if Jason hired an attorney in this case to defend himself, but the attorney's fees that were incurred by both of the parties are likely significant because this now went to litigation. And what that is going to do is reduce the overall value of the estate that is available for distribution to the beneficiaries. And for Emily and Lily, it's particularly significant because they not only have to pay their own attorney's fees, but they're also bearing a pro rata share of Jason's attorney's fees, because Jason is, if he hired an attorney, he's likely using trust funds to pay for that attorney, as trustees are entitled to do. So they're bearing a disproportionate share of those attorney's fees just to file an action to get Jason to do what he had an obligation to do in the first place. So this is, from a beneficiary standpoint, incredibly significant. If a trustee breaches their duties, ultimately it's going to just reduce the value for everybody. And then of course there's the family aspect to this. Litigation does not help out any problems in relationships between family members. It usually exacerbates those problems. And so it's another cost of this litigation, another cost of the administration of this trust is the damage to the familial relationship. Next slide. Okay, where did this administration go wrong? So number one, there wasn't early structure for Jason or professional guidance. So it seemed like what he did is he just kept doing everything that he was doing before, and without any change to acknowledge that there was a significant change in his role, right? So now, after the death and after he steps in as trustee, he has fiduciary obligations to Emily and Lily, and that's it. Continuing to operate as he did before is not going to work, and it's not going to be an excuse. So getting counsel in from the beginning to advise you, look, this is something you can do, this is something you can't do, is very important, because oftentimes fiduciaries don't even understand that there is a difference. Obviously, failing to communicate with the beneficiaries and providing them with incomplete information is what started the suspicion in the first place. In this particular case, they weren't even given a copy of the trust for several months. When they did ask questions, Jason tried to just blow them off. That is not conducive to a good working relationship with the beneficiaries. Keeping them informed from the beginning would have been a much better course of action, because it probably could have prevented a lot of these things from spiraling. Poor documentation leads to an inability to defend the actions that you're taking. Again, the reimbursement to Jason is a very good example. It is not uncommon for fiduciaries to use their own funds to front money for the trust, either because there's a delay in being able to set up a trust bank account or whatever the situation is. And so it's very common for a fiduciary to seek reimbursement from the trust. That does not necessarily mean that anything has gone wrong, that they're acting improperly. But if you cannot document and substantiate that reimbursement and show this is what the reimbursement is for, here's the money coming out of my account, here's the money going back in, is incredibly important. A lot of times people may try to cover up improper transactions by claiming reimbursements, but if you don't have the documentation, then it's really easy for somebody to say, it's not a reimbursement. And then blurring the role between beneficiary, trustee, and then business operator. Obviously, in this case, Jason was just acting as the same in all three of those roles, when you really have to be able to put on the different hats and understand the differences. What could have prevented the litigation? Obviously, immediately hiring counsel and a CPA, right? There was also tax issues in this case, which could have been resolved by hiring a CPA who's knowledgeable in this particular area about making proper tax elections on behalf of a trust or an estate. Can make a huge difference. Sending out regular notices and accounting updates to the beneficiaries. There are lots of ways that a trustee can give information to beneficiaries. It doesn't have to be through formal court action. You can do it through notices of proposed action. It doesn't even have to be formal. It can be informal updates, so long as you have a paper trail. Obviously, if he would have prepared professional accountings from day one, that probably would have reduced a lot of the suspicion by Emily and Lily, and could have prevented the hiring of counsel on their end, earlier. Documenting all of the decisions. It's super important as a trustee to make sure that you have the documentation to support everything that you're doing. Everything should be in writing. Make sure that you understand the importance of being able to defend your actions. Sometimes things start out really well between the trustee and the beneficiaries. And so maybe it's not front of mind to a trustee to make sure that there's a paper trail, but over time, things can start to fall apart. And so at that point, maybe then the trustee starts thinking about a paper trail, but it could be too late for what happened earlier. So starting from day one, understanding the importance of that paper trail is incredibly important. And then getting valuations of the business. Again, this is something that's important primarily for tax purposes, but it will also just show, the professionalism of the trustee in terms of checking the boxes of what they're supposed to be doing as the trustee. Next slide. And that is everything that I have for you all today.
All right, Lindsay. So it does look like we have quite a few questions.
Sure.
The first one being from Daniel Fong. What is the proper format of trust accounting? Do you recommend hiring a CPA to do trust accounting?
In my experience, most CPAs don't know how to do when we say a formal trust accounting, we're talking about the format that is set forth in Probate Code Section 16063, and it specifies certain schedules and what needs to be on those schedules. In my experience, I don't think a lot of CPAs are familiar with that particular code section and those schedules, because it's different from like an accounting that you would do in like a company. So you should try to hire somebody who has experience preparing fiduciary accountings, trust or estate accountings, because they're going to know how to do that. And it's going to be, preparing a formal accounting, there is an expense associated with it. So sometimes trustees or beneficiaries don't want to incur that expense, and that's fine. But if you are doing a formal accounting, either because you've been court ordered to, or because you want to submit it to the court, you want to hire somebody who knows how to do that particular type of accounting.
Alrighty, I have another person asking Robert Brower, is the potential for a federal court action a reason to use a will instead of a trust?
I'm sorry, what, can you repeat that question?
I guess context, I'm a successor trustee in a federal diversity case, and not too sure where. Is the potential for a federal court action a reason to use a will instead of a trust?
So a probate is a state court action, just as a trust is. So I don't think that whether you use a will or a trust, or whether you have a will or trust, factors into whether it's a federal or state court action. Both of those are state court actions.
I have someone asking a question regarding moving in. Is it acceptable to have the trustee or beneficiary move into the real property rent-free to maintain security rather than have the property sit vacant?
So sometimes that is how a trustee will justify living in the property rent-free because of security, because they're making repairs to the property, whatever is the case. It is a case-by-case analysis of whether that's going to be appropriate. Again, the duty to make trust property productive is a general duty. So how that looks in each particular circumstance may be different. In my opinion, a trustee moving into a property rent-free just because of security purposes is not going to be sufficient to overcome a potential breach of that duty. There are other ways to secure property that don't give the trustee a benefit that other beneficiaries are not getting. You could get an alarm system. You could have tenants move in and charge them rent. So that in and of itself, I wouldn't say is going to be sufficient. But that being said, if you get the consent of the beneficiaries, then obviously that's okay. At the end of the day, your liability runs to them. And if they're okay with it, then it's okay. But that would absolutely need to be in writing. The other way that can be handled is you can move into the trust property and not pay rent on an ongoing basis, but agree to have it treated as an advance against your ultimate share if you are an ultimate beneficiary in the trust. And that way you're not breaching your duties, but you don't have to come up with the money up front if you don't have it.
Great, thank you. And I have another question. If the trust is silent, what is the default provision for discretionary distributions? The ascertainable standard?
I'm not aware of a default standard for that. The HEM standard is set forth in the Internal Revenue Code. It's not in the probate code, so it's a tax issue. Again, I'm not aware of what the default discretionary standard is, other than you have to exercise good faith in when you are making discretionary distributions. That is across the board. You have to have good faith. Even if you're given absolute discretion, you still have an obligation to exercise that in good faith.
Thank you. And I have another question regarding the hypothetical. Is Jason's attorney at risk if he fails to keep Jason in line and continued breach by the trustee while represented by counsel?
So is there liability to the attorney for Jason?
Yes.
From who? From the beneficiaries? I don't think that the trustee doesn't owe, I'm sorry, the trustee's counsel does not owe the beneficiaries any duty. They are not his client. Jason is only his client. But we can't control our clients. All that we can do as attorneys is advise them. So, I can't physically make my client do anything. I can advise them as to what their obligations are and tell them what would happen if they don't follow that advice. But I can't physically make them do anything.
All right. And I have another question from Thomas. When a trustee dies, who is responsible for preparing the accounting?
Okay, when a trustee dies, who is responsible for preparing and accounting for that trustee's administration? I'm not sure that there is a specific person who is responsible for that. I would assume that the successor trustee would have an obligation to try to put together an accounting to the extent that they can. But I would imagine that the court would be understanding if they didn't have all of the information because the trustee didn't keep records, for instance. but there may be some transactions that you can recreate using account statements, for instance.
This concludes today's program. We would like to thank our speaker today, Lindsay Munier, for an excellent presentation. Our next program will be on May 19th, our annual litigation update featuring Scott Ron and Nick Van Brunt. Thank you all for joining us this afternoon.
Thank you.